The Standing Committee on the Law of Patent held the 27th session from the 11th to the 15th of December in Geneva. And it had been a very interesting session for participants, both coming from capital and delegates in Geneva. The session had been a very intensive one, developing as traditionally 5 agenda items, but with particular emphasis in substantive patent law issues. Since the beginning, we start with a very interesting document on one exception and limitation in the patent field, that is the regulatory review exception. And a draft reference document has been prepared by the Secretariat and presented to the committee, triggering the interest and attention of member states that intervene, extensively exchanging ideas about the document in itself and the content of that document. Then we move in other issues, like, for example, we have an interesting session that was a sharing session on the issue of databases and accessible information, legal status patent information in databases, particularly in the area of pharmaceutical products and medicines in general. This session comes with the participation of certain invitees, like the Mexican patent pool that introduced their database, MedSpal, that create great interest by participants. And at the same time, they ask for more. So we will continue working on this issue and exploring what are those databases available, including a WIPO initiative in this regard that is called Pat Inform, that probably will come in the next session of the committee. We have a very interesting session on inventive step, where the way inventive step is assessed was illustrated by experts from different patent offices with very concrete cases, in which they show how this requirement of patentability, that is a very complex one, is assessed in the different offices. And these show, in my view, different elements. One, that there is a great level of coincidence among patent offices in this regard, but at the same time that there are very diverse practice in the office with laws that are quite similar. So it shows that even in those cases, the policy space for patent offices in implement that laws with different policies and elements into consideration is always there. And that is, I would say, a remarkable conclusion coming from the different exchanges. Then we continue on a sharing session on the cooperation among patent offices in the issue of share and examination. This is an area of particular interest, taking into account the amount of patent applications that are filed every year. Patent offices are very eager to consider what are the options they can cooperate among them, and how this cooperation will benefit the offices directly, and with benefit also applicants, since many of the applications will be decided in a shorter period of time. So those issues are among the many other the committee discussed during this very intensive session. Something that was extremely important in the meeting was the spirit of openness and flexibility that all participants shows, and they were used looking for more and more information on substantive patent law issues. And at the end, we always arrive to the issue of the negotiation of the future work of the committee, that is not a simple one. And in this case, both delegates and regional coordinators did an excellent job in and discussing among them what the chair has proposed at the future work, reaching a consensus again that allows the committee to continue in the future session with a very interesting agenda, as substantive and as relevant as the one we have in this session.